Mr. Burgess, please.
Yeah, this is Robert.
Hi, how are you, Oliver Gordon?
Yeah.
So, how are you?
I'm okay, yeah.
Oh. I understand, Mr. Burgess, you're still sending emails to Director Martino.
Yeah.
I'm assuring you that he did respond to you, but he's aware of the situation, and regarding the file, he's not in a position right now to reopen the file, if that's what you're after, or to say it's covered up. I think we've thoroughly looked at the information.
Yeah.
As promised, what I'm going to go over is a little bit more details, how you arrived at a decision. You up to that?
Yeah, yeah.
Okay, so you called the police service on June 18th, saying you're sexually assaulted.
I called on June 13th, actually.
June 18th.
No, they say the Hamilton police contacted them, but I contacted them.
Okay, contacted us. Yeah, so they contacted, so what happened? You called and they contacted us.
Yeah.
Okay? You said you were sexually assaulted on June 13th.
Yeah.
Of course, there was a pat-down search at the Hamilton station, correct?
Yeah.
So what we did then, we started the investigation. We identified who the officer did the pat-down search, and our terminology, we call that officer the subject officer. Okay?
Yeah.
And the director then reviewed all the information collected and assessed it, and found there were no grounds to believe the subject officer committed a criminal offense in connection with your sexual assault allegation. Now, you went on to say that, you know what, the sexual assault, as you're aware, because you're doing your research, and that's why I'm taking the time to go over this a little bit more with you. And Director realized that a sexual assault consists of an assault and committed circumstance of a sexual nature, right?
Yeah.
That sexual integrity of the victim is violated. And that's a case I'll call R versus Chase.
Yeah.
Okay, I know you're thinking of case law, but that's one you want to take a look at, okay?
Yeah.
And then, so now, whether that contact in question of sexual nature, that court asked us, the judge asked us, advised us today, take a look at on an objective scale assessment on the prevailing circumstances at the time, right? And taking consideration, stuff like the body touch, what part touch, the nature of the touch, and its purpose. So any words or gestures accompanying the touch. So, for example, whether the officer saying anything that accompanied the touch, and the situation which has occurred. That's what the judge's guidance was in case, right? To take a look at any circumstances that you have these type of cases. Here are some considerations of things you should take a look at to assess the current situation. So Joe did take a look at those, Director Martino. He did take a look at those, and he's unable to conclude that contact was in a sexual nature.
But touching somebody's genitals is sexual nature.
And let me go over that a little bit more in details, and I'm going to get there, right? So he then go on to assess, because Joe's very thorough, Director Martino's very thorough, to assess whether or not part of the thing we have to do in our case is to see if he had authority to arrest you in the first place, and Joe did that assessment in terms of the trespass, and came to the conclusion that the arrest was okay. Okay, so we'll move on to the one second. So he determined on his review that the arrest was lawful. So if the arrest is lawful, right? So now they have a lawful authority, right, to arrest you?
Yeah, but not a lawful authority to touch my genitals.
Yeah, okay, so they have a lawful authority to arrest you, then they have a lawful authority to search you, right?
Yeah, but not to touch my genitals.
Okay, I'm going to get there, okay? So the search is therefore authorized pursuant to the common law power to search, right? So the officers now are allowed to search. Let's just get that they're allowed to search. So then Joe goes on to say, finally, he's satisfied the search is conducted in a reasonable manner. So now, although they're authorized to search you, the case law says that, hey, the search also has to be conducted in a reasonable manner. So how do we get there to determine if it was, in your case, it was done in a reasonable manner? There's video recording that captured the search, right?
Yeah.
So Joe, Director Martino, accepted that the touching occurred, that some touching occurred over your genitals, over your clothing.
Yeah.
Okay? So this is the important part now, Robert. I need you to understand, is that, yes, they're authorized to search. Director Martino didn't say that you were not touched. It occurred over your clothing.
Yeah, it's still sexual assault, though.
But the contact, though, when you're assessing it on an objective scale, overall, the contact was fleeting and part and parcel of lawful exercise of duty.
No, it's not. It's just not. You're not allowed to touch someone's genitals when you're searching them.
Well, it was over your clothing.
Yeah, that doesn't mean it's not sexual assault because it's over your clothing. There's lots of cases where people touch each other on top of their clothing, and it's still sexual assault.
Okay, Robert, I'm not going to, I called you today.
Yeah.
To just go over a little bit more details, which I accept, okay? You're probably not going to accept my explanation or Director Martino's explanation. But there was nothing, I've reviewed the file. I've reviewed the file myself, and I 100% agree with Joe's assessment. Perhaps you probably need to take some time to digest what I'm trying to say. But there was nothing else that we can do, and I want to give you any hope to reopen this file or to look at this file again.
Okay.
Okay?
All right.
All right. So I appreciate it for you taking the time to hear me out. And again, Director Martino is not saying that except that there's some touching, but the contact was fleeting. And part and parcel legitimate.
But the Supreme Court says the touch has to be with intent to apply force. They don't say pleading is not sexual assault. They say intentional touch on a genital area is sexual assault. The Supreme Court says that. It says you have to prove general intent for a sexual assault, which means he touched me with the intent to apply force. Doesn't say anything about pleading.
So this is why we did not. This is why Joe used the word pleading. There was no indication from the video that the officer applied force.
No. When they mean applied force, they mean touched me on purpose.
Touching. So the pleading was, so an officer can touch you in the exercise of a legitimate search.
But you're not allowed to touch someone's genitals when you search them.
Okay. Well, Mr. Burgess, again, we're going to go in circles on this debate, okay, or this discussion. I suggest, and you may want to seek or find out a little bit more about this area. But as far as the SIU stands, we cannot, I reviewed the file myself as investigative manager, and I accept Director Martino's opinion on this and decision on this, not opinion. And unless there's anything concretely comes open that you could point out to me, I'm afraid that I cannot bring this forward to Joe for any more consideration. Okay, so otherwise, thank you very much for your time.
Yeah.
Okay?
Okay.
Thank you.
Bye.